Tony was going, or is that we can tell you that just tells you so. they not gonna be?
he commenced the special proceedings before the special magistrate for the city of Palatka, Florida code enforcement. By way of introduction, my name is Ron Brown. I'm an attorney licensed in the state of Florida. I've been authorized by the city commission of the city of Palatka pursuant to state ordinances, state statutes and the city of Palatka code to preside over these proceedings today. This is what is called a quasi-judicial proceeding. It is not a formal court of law. It is not an administrative proceeding under either the state or federal administrative code. The chapter 162 of the Florida statutes, which authorizes these proceedings, provides the basic guidelines for how we shall conduct the proceedings, and we will follow those guidelines. One of the things about it is that the formal rules of evidence that you might find in a court of law are not followed. We do have to follow basic common sense due process requirements. That is, treat everyone as fair as possible and equally as possible when it comes to presenting evidence and testimony. And we will attempt to do that. What will happen today is that the city will be making a presentation regarding the alleged violations of the code. They will be presenting their evidence. It may be testimony, it may be demonstrative evidence in support of the violation. The respondents at present will be allowed to have an opportunity to make their own presentation, presenting the evidence that they have, and each side will be allowed to question the other. It is not a highly formalized proceeding, but it will be one that we will conduct on a very genteel and organized way. And the reason for that is that we want to make sure we have a very clear record. You'll notice that there is a court reporter here who is transcribing the proceedings. And the record is also being recorded as a part of the city's requirements. These will be available on appeal if necessary, but we want to make sure that everything is as clear as possible and that everyone has a chance to participate. One of the essential requirements that a reviewing court looks at is that any evidence presented be what is called substantial and competent evidence. And the basic requirement for that is that it be based on the personal knowledge of the person testifying and that it also be taken under oath. That being the case at this time, I'd like to ask everyone who will be testifying today. If you're an attorney, you don't have to do this, obviously. But if you're going to be testifying today, I'd like you to stand, raise your right hand. We're going to administer an oath. Do you solemnly swear or affirm the testimony you will give today will be the truth, the whole truth, and nothing but the truth? And everyone has indicated an affirmative. What we're going to do is the county will call the cases and make their presentations and presenting the evidence that they have, and we'll try to direct traffic as far as that goes. So, let's go right. Which first case?
Well, we're going to skip a little bit. The first case we're going to do is 2019045, 822 Oak Street, Palatka, Florida.
Okay. Is there anyone here who is responding in that case? Yes, sir. Coming forward. And what you might want to do if they're going to be here, you might want to move back over there and let them have that. Just keep them distancing. Thank you. Could you identify yourselves for the record, please?
I'm Emmanuel Shami,
And what is your relationship to the property?
the owner.
You're the owner of the property. Very well.
I'm Rusty Collins. I'm
Yes.
the attorney. for,
I'm familiar with Mr. Collins. Thank you. All right, Mr. Cartwright.
Good morning, good afternoon, everybody. This case right here, actually, I'm bringing to the magistrate because I'm trying to get a resolution to see how we're gonna close this. This case predate me taking over the code enforcement office, but we have the property at 822 Oak Street has really coded 30-32-8 prohibited condition in public nuisance, description weeds and overgrown grass. This property has a date of first observing on March the 28th, 2018. Notice for hearing was sent out on February the 5th, 2021, 10 days before hearing. Date of correction was October 24th, 2018. No green card was signed. Complex posting was done on February the 5th, 2021. Site that I did myself was February the 5th, 2021. This case dates back to September 26th of 2018. It's actually running a lien fine of almost $83,000. And I'm trying to get a resolution. We do have some discrepancies in the code enforcement officer and the property owner communication. We noticed that on the 24th of October, the property owner received a letter from one of the officers and stated that the property was in compliance. But it was not. We still have some liens and stuff with the county. And what I'm suggesting here, and documentation in here to prove it, is that we actually run the fines from the October 5th until April the 5th, 2019. And it closed out at $16,300.
So what I'm hearing is we've had an order finding a violation with a date of compliance and $100 a day fine in the event of non-compliance. And that order was requiring corrective action by September 26th of 2018. Is that correct?
Yes.
And then from that date, the fines accrued to the point of, if they were calculated today, would be $85,500. The city wants that reduced based on what particular issue again?
Evidence that at that time, the code enforcement officer communicated with the property owner that the property was in compliance,
Okay, when in fact it wasn't.
when in fact it was.
Has it been brought into compliance since that communication with the property owner?
The pictures on the right shows that the property actually,
Okay, just so we're making a record, what are we looking at?
the pictures on the right is 822 Oak Street. Pictures was taken by myself on January 13th, 2021.
And Mr. Collins, do you have any of these documents that he's looking at?
I do not have this set of documents.
Okay. And we're going to try to build a record based on making as precise as possible set of references to what we're looking at. The clerk is rolling the electronic version of this to some photographs, which are sideways. Here you go. Is this the one you're referencing, photograph number
Yes,
one?
Photograph number one.
All right.
Property seemed to be in decent and standard condition. We have photograph number two. Only major damage I see is a screen and doors open, but we do have a tenant that's supposed to be living in there, so the doors can be open.
And just for the record, the original complaint had to do with a violation,
Of weeds and overgrown grass.
excessive unattended growth of grass, weeds, brush, branches, and other.
Another,
It was a section 30-32A of the code.
yes. So we were dealing with the weeds and overgrown grass from what I was reading in the initial property.
Okay. And just for the record again, I'm looking at this, I'm also looking at these in a matter of first impression. The violation description looked like it was originally screening required for trash areas, dumpsters, and outdoor storage areas visible from any public street or from residential uses and zones. So screening is what was required to bring the property into compliance. Is that correct?
Mhm.
And the screening was not put up. Is it put up now?
As of the pictures right here, the screens are still not up.
Okay, so show me, it looks like a fence there.
Yes.
So look at your photo number one.
Mhm.
And what in that photo is out of compliance today?
From my eyesight, I see nothing that's totally out of compliance.
I'm sorry?
Nothing out of compliance.
Okay, what about photo number two?
The screen is the only one that I see that could be possibly out of compliance.
Anything in photo number three?
No.
Okay. And photo number four looks like the side of the house. Is that, what's the relevance of that particular photo?
Just to show you that from the initial screens and everything that was out of compliance, that only the one screen that we noticed on this last inspection was out of compliance. Okay,
Look at number five
And that's
then.
the same view of photo number two, just at a lower side view. That's the same
Okay.
screen.
So and again, I want to make sure I understand the requirement for compliance was to put up some type of screening around whatever was the trash area, dumpsters, or outdoor storage area visible from a public street. And we see this fence here, number 5, which I guess doesn't border Oak Street. Is that in between the
2 properties.
2 properties?
Yes.
Okay. So that's not, that is or is not a compliance with the original order.
The original order for my reading, everything is compliant.
It's in compliance now. All right, so they're in compliance. Do you know when they got into compliance?
This date predates me. I can only go from the date of the picture of the January 13, 2021.
Okay. Well, the staff recommendation on this was to release the lien and reflect a finding of fact conclusions of law that was closed. And then it just says totaling in the amount of $16,300 after 163 days. So what's that about?
That is the date of when the lien started until the date we have communication between the property owner and the code enforcement.
So you want to release the lien entirely?
No, I want that fine of 16,000 to pay, but I wanted to go into the communication chain between the two, the code enforcement officer and the property owner.
Okay. So you want the lien to run from 10/24/2018. So on 10/24/2018, this fencing wasn't up. Is that correct?
See, again, it predates me. I can only go with what I seen when I.
Oh, I understand that. I'm just trying to sort out what the evidence was in regard to the situation. Because I anticipate you're going to be asked some questions concerning, how do you know that it was out of compliance on October 24th, 2018? You're saying you don't?
And I'm ready to answer those questions.
Do you have any idea when it was brought into compliance?
No, I do not. I can go with the conversation of when I went out there in January the 13th of 2021. This is when it was brought to my attention that it would be an issue and concern. So that's when I went out there and took repictures.
So the first time you saw the property was in compliance?
Yes.
Nobody else at the city has any personal knowledge of this?
The young lady that the code enforcement officer that we had predated, no work for the city anymore. And I didn't reach out to her to kind of get an idea because we do have an issue with the letter saying that it was in compliance back in 2019.
Anything else?
No.
Okay. And just for the record, usually it's only the city commission has the authority to reduce the lien. So what's happening here is a recommendation to the
Yes,
city
a
commission?
recommendation to the city commission.
All right, just so everybody understands the process. Usually they're the final authority once the lien's been established in the amount. Mr. Collins? Anything you'd like to respond to?
I would like to introduce a document into the record
Okay.
for the court here. I have a document that appears to be an email. And Mr. Ashami, I'm showing you a document. And what I care about is the part that's between here and here. What is this a copy of? Where did it come from?
This comes from.
Would you mind if I took a look at it
Yes.
first, just help orient myself a little bit? And we're going to keep it, by the way. Your sister. All right, I will mark this as respondents 1, just an R1, top right. This is an email.
And it's the middle section that we're talking about.
Tingler Clark Jackson at Palatka, Florida government, dated October 24th, 2018. Okay, thank you. You got.
Mr. Ashami, can you give me the circumstances around this email that we just identified?
After the first hearing with the commissioner agreed that to give me 1 month to fix all the property, fix all the damage with the property. And after this month, I will get penalized $100 a day if I didn't. So I started working in it and communicating with Officer Jackson that I did this, I did that, till in October 23rd, 2 days before this month it's up, I emailed her. I said, I did everything in the list, and I would love for you to come to check it out. So see if there is anything needed, anything else needed. She went there, she checked the property, and she sent me the email, and she told me that every violation has come to the code and you already fulfilled everything.
So what did this email mean to you?
It's mean that every single violation that I had a problem with the office, with the code enforcement and the city, I fixed it.
Okay, ma'am. Mr. Cartwright, have you seen this?
Seen a version of this, yes.
A version of it?
Well, I seen it on the.
You know, lawyers react to that kind of
Right.
language.
This is the correspondence I said that we had between the code enforcement officer and the property owner.
And Tanglear, is that correct pronunciation of that name? Is that correct? Anyway, Tanglear Clark Jackson, as I read this, and first of all, is there a question as the authenticity of this from the city's viewpoint? You don't know?
No, I mean, it was discussed and deemed to be a legitimate.
And that's when the police department was involved with code enforcement.
Yes.
What it says is to Mr. Elchimy, right, and make sure I got that correct. According to this, Ms. Tangle or Clark Jackson went out. I did go out to the property yesterday, October 23rd, 2018, which was, according to the summary of the case, was the day before the compliance date in the original order, finding violation, and re-inspected the property and saw that every code violation has been brought into compliance. Please continue at the property owner to keep your property in compliance by the City of Palatka Municipal Codes. I'll also be sending you a letter in the mail this week regarding the re-inspection outcome, fees and fines or administrative costs. Should you have any questions, please contact me. Did you get a subsequent letter concerning any of that? Does the city have any record of any subsequent letter?
No.
Okay. Well, this is saying that the code enforcement officer said they were in compliance prior to the compliance date.
This is why we're here, to try to get an idea of what we're gonna do with this case. But yes, I read that and
Okay,
Can I inquire now?
yeah, you may.
Are there any words in that email that are not clear?
no,
Is there any other conclusion you can come to from that email that the issues that were made in the September 26th findings of fact, conclusions of the law and order were not complied with?
from this email, no.
Okay. So you think Mr. Alshami was justified in relying on the word of that code enforcement officer that everything was in compliance?
I'm sit here and say I cannot tell what either the code enforcement officer or the property owner was mindset at the time, because this predates me, so I'm not going to give my opinion to that. But I do think that the letter itself is a reason why we're here today, trying to reduce the fine.
Okay. Does the phrase "every code violation has been brought into compliance," does that mean anything different in Palatka, Florida than it does in the rest of the state? Because I graduated from Palatka High School, so I know what they teach here.
And sir, I'm not from Palatka High School, so that's not relevant to me about your graduation. But at this stage of time, I will refer to the letter, and it seems like that she said everything was in compliance. And I would defer to the magistrate on his decision on what we do.
Okay, now where did you get the number? Was it $16,000 or $18,000 in fines you want to assess against Mr. Alshami?
$16,000, and that runs from 2000 December 2018 to December 18, 2018, and later released on April the 5th, 2019. That is when the things in the court documents that I've read was everything was released out.
Okay, so you're saying because that, now you understand that that lien was recorded twice, don't you?
Yes.
Okay, so do you, why was it recorded twice?
Can't answer that question. I was not the one to record it. I was
Okay.
not even over code enforcement at that time, so I can't answer the question of that.
Is it your testimony that from the December recording date to the April release date, that Mr. El-Shami was not in compliance with the September 2018 order?
That my testimony is I first seen this property in January of 2021. So I cannot testify that he was or not in compliance.
Then how is it that you're coming to court today is trying to assess a reduction from when the code enforcement officer says it's in compliance on the day of the deadline?
Mhm.
How are you coming back and saying in December, after he was in compliance with the order that was issued in September, that he was not in compliance and you want to assess a fine?
Because I'm going with the documentation that we've seen in the court records. This right here is I was aware of the conversation, hadn't seen his proper documentation or self. So I had to go with what I had tangibly in my hand to go with. And that's what I came up with, the fine in facts of $16,300. New information has been put into my face in front of me. And I understand how he can see that he thought he was in compliance before the 30 days. So the magistrate recommends that we lower the fines or whatever, do away with the fines. I'm okay. Right now, my whole purpose in this situation is trying to close the old cases so I can get started with new cases.
Okay, so as you sit here today, right now, you still want the $16,000 or $18,000 you asked for?
I'm just recommending this case to the magistrate to make a decision. If he says that we can't get the $16,000, I'm fine with zero.
Why do you think the city should be entitled to the $16,000?
My personal opinion, I'm going on the documentation that I had in front of me when I was making these decisions. With this new letter, I can see that we probably wouldn't be recommended to get anything from this fine because it seemed like he was in compliance on the 29th day of his opportunity to get 30 days.
Okay. Do you agree that the lien or the document that was filed in December referred to the September 26th date?
Do I agree with the document that filed in September?
The December document, the December lien you talk about.
Mm-hmm.
What hearing was that based on?
I'm running a blank on this one, but that was based on the December. No, I don't have it in my documentation here.
Can you find it? I mean, is it on the screen that you have? The detail?
September 26th, a cause and fact and finding of the law, September 26, 2018. Gives him the 24 days effective 24 days on 24th of October 2018 to continue court correction actions. Anything after that. So this is what I'm looking at. October 12th, 2018.
What date was that recorded?
October 12th, 2018.
When was it recorded in public records? It'd be at the top of the document, probably under the password.
October 15th, 2018.
Okay. So that's not the lien that was filed in December, was it?
When filed December was recorded 2018, December 2018 at 3:44 p.m.
What hearing date does that refer to?
No, that was the 12th. That's the day it was signed. Hearing date is referring to September 26, 2018.
You would agree that's the same hearing date then, right?
Yes.
Okay. And for some reason, that's just does that look like it's probably a duplicate of the same lien? I mean, it's not the same piece of paper that was recorded, but it's a duplicate of all the same information, right?
Mm-hmm.
Can you have two liens with one hearing?
No. So your recommendation is what, sir?
My question is, so you've relied on a lien document that was recorded after the date of the compliance, when the code enforcement officer said it was in compliance, right?
Mm-hmm.
And you knew this before you came today, right?
Mm-hmm. I knew about the new lien dates. This letter right here, I was told about, hadn't had physically seen it.
Okay, so you were told about it. Did you inquire? Did you look for it? Did you ask for the email? How come?
Because simple fact, this is the reason why I started this right here to try to close this out.
So,
Because there was a lot of miscommunication information in the whole case. So that's why I wanted to bring it to the special magistrate to kind of get an idea of how can we close this
so
case.
why not just back down and say we're not entitled to any lien?
That might have been a recommendation, but at the time I thought the 16,000 from April the 5th, from our October 24th to April the 5th was the dates that I was looking at.
But as you sit here now, you know he was in compliance, right?
This is what the letter says. So yeah,
Okay, so you believe he was in compliance?
the letter states that he's in compliance. I'm not gonna say what I believe.
Do you have any information that says he was not in compliance?
No, I do not.
Okay, so if you have no information, he wasn't in compliance, and you have a letter that says he was in compliance, what's your result?
My result now, like I said earlier, that I stated that I see that he was compliant within the 29 days or the 30 days that he was given.
Okay, so with that, is it still your recommendation?
No,
Okay, so you withdraw your recommendation?
yes.
So you're saying that the lien should be released?
My personal recommendation with the information that I have on hand, not saying that any other information out there that can contradict this, that yeah, the lien should be
Okay,
released.
not your personal recommendation. You,
Lien-
as your,
lien-
in your job.
At the information that I have on hand, yeah, the lien should be released.
Okay, and is that what you want the magistrate to do?
That is my recommendation to him right now, to take a look, but this will be subject to the commissioner and the city manager's decision.
Wait a minute, do we have to go in front of commissioners about
So
this?
just to make sure I understand, you've asked for the lien to be released.
Mhm.
I think the bone of contention is there any residual fine that's due?
Other than the legal fees that would probably occur to this, as far as the letters and everything we sent out.
Wait a minute, okay, because the city has improperly gone after my client for $80,000. Remember, we've had several hearings, right? You know that.
I've heard of it.
Okay,
yes.
did you look at the videos from them?
Yeah, I was on the last video with him.
Okay, so you know that right now you sit here, you know that the city came in and went after Mr. El Shami for over $70,000 in lien. You wanted to foreclose the lien, okay? And you want legal fees for doing this foreclosure when you know you didn't have the right to do that?
It's still legal fees accrued to the letters that we sent out, certified letters and everything. It's still legal fees that accrue no matter what.
What about Mr. El Shami's legal fees for your improper actions?
That's Mr. Shane's right to do. what
First
he
of all,
believes
just for the record, I'm not sure what authority 162 provides for legal fees for anybody.
Well, he's saying that there's fees.
I'm just raising the question. I don't
Okay.
know of any authority in chapter 162 that provides for legal fees.
Well, I'm wanting this issue to be resolved. and done.
Administrative fees. Misproper
Okay.
spoken words, administrative fees. though.
Okay.
Yeah.
But those administrative fees came in October because whoever was in charge didn't recognize that Ms. Jackson had
All right, Mr. Collins, I'll tell you what,
beat the thing to death.
maybe we can resolve this. Here's what I'm looking at. And Mr. Holmes, I don't know if you want to interject as we get this point, or you would like, Mr. Holmes would like to interject something. Please feel free.
Your Honor, this case predates all of us. Right myself. From what I've heard today, it would be my position, as you know, on the city commission, you can't release a lien. That's what happened. But from what I've seen today, my position, I recommend the city commission that they release all liens and declare. They remove fines or also.
And let me follow up with that if I may, and I appreciate your comment. And this is the first time that we've come into the special magistrate situation in the city. I deal with the county all the time out there. I was out there this morning. And I've had situations before where the code enforcement officer is the individual who is left with the responsibility of trying to sort out what happened according to his predecessors, who happen to be in an entirely different department of the city at the time. And so this makes for some very difficult proofs with regard to evidence. And it can cause some confusion. I'm impressed with the fact that it looks to me like there was compliance by the compliance date. And unless there's some evidence to, in contrary to that, I can't find any reason to establish recommend a fine at all. And again, I appreciate what you're doing and what you're trying to do. I know you're trying to preserve as much as possible what the city's actions have been. So unless there's something else, my recommendation to the city commission is that based on the fact that we have an initial order to take corrective actions 30 days from September 26, 2018, which by my count was October 27th, 2018. And it looks like, according to the letter in the city's code enforcement officer at the time, there was compliance 4 days before that date. It looks like the order was sent out. The order was entered in on 10/15, but there was not compliance by 10/24. At any rate, it looks like the compliance was even on that circumstance by 10/23. So it looks like, according to the facts of the case and the city's records, there was compliance before any of the dates, which would have triggered a fine. And I regret that's the first thing you get to hear with regard to this. But sometimes that's what happens. And I know you're trying to sort through all the records that have preceded you, but I think in this particular case, we're going to make a recommendation that lien be released with no fines or fees attached to that, simply because there appeared to have been compliance according to the email dated on October 24th from Tanglear Clark Jackson of City Palatka.
And those are findings of fact?
Yes.
Okay. Thank you.
All right. Thank you. Everybody having fun yet? All right. Make sure this email is in the record.
I got it.
You have it there. I'll make sure that who's keeping the official record of the hearing? The clerk? Okay. Somebody needs to make sure that at the end of the day, someone has all the evidence that has been presented in the hearing and have that under control, and you will have that in the official file. Okay. Next case, anyone here who is a respondent in another case? Mr. Cutright, what's your next case?
Next case, we would go back to the top.
Okay.
And the next case would be 2019-020, 21 North State Road, 19.
321 North State Road 19. Okay. Case number 219-20. Is anyone here who is an owner or respondent with regard to this case? And seeing and hearing no one, Mr. Cutright, you may proceed.
All right, this case right here originated violation in the code of Palatka, Florida, 30-32A, prohibited conditions and public nuisance. Description: weeds and overgrown grass. First observed was on May 16, 2019. Notice of the hearing sent out was February 2005, 2021. Date of correction of the property, September 28, 2019. No green card was signed when we sent it out. Complex posting to February the 5th, 2021. Site posting, same date, February the 5th, 2021. First hearing date was August 28, 2019. Proper owner was or was not present. So we can't relate to that.
You did not get the green card signed at the official address. Just for the record, the official address of the owner Miss McKinnon Furniture is the owner.
It's been sold twice. The new owner, the representative is Alex Fryer that I've been speaking to about the property. The new owner is Troy Nettles.
So when we sent out the initial notice of violation, who was the owner at that time?
The representative for, we had a B&B Palatka Ltd.
Okay, and that was at 523 Michigan Avenue, Miami Beach. Okay, and you sent out notice to that person at that address? Did they appear at the hearing or offer any response?
No.
Okay.
Only person we've been dealing with is Alex Fry, the representative
Right.
for them. He's
So at the time that the finding of fact conclusion of law was entered on 8/28/19, who was the owner?
Alex Fry.
Who is that?
Well, Alex Fry was representative of B&B.
And Michael, a quick question, make sure we got notice to the right people.
BB Palatka LDT.
Okay. And they're the ones who are currently the
Yeah,
owner?
the new owner is Corey Nelson. He just recently purchased the property, I think, a couple months ago.
And you never got a green card back from any of these people?
I don't think I've been speaking with Alex Fry, their representative.
But he didn't sign.
We didn't sign. But
Okay.
we have had correspondence
And
through
did you
emails.
post the property or,
We put a sticker note on the property.
okay. And you signed the affidavit of posting? There's an affidavit you sign when you post the property.
Okay.
Okay. So what you want done today
It's
in the daily fines as of October 14, 2019, to reflect the last date of the previous code enforcement are intended to reschedule the inspection. So what are you looking for today?
on October, we have a conversation between the code enforcement officer and the compliance with the property owner, saying that the property owner stated that he had brought everything in compliance. He sent receipts and the invoices of work done. And the code enforcement officer said that they would go back out and re-inspect the information on the date of October 14, 2019. So
Okay.
my recommendation, with no documentation from that point on, showing that the code enforcement officer went back out there and re-inspected the property, my date was to run the fine from when they noticed the situation of September 28, 2019 to October the 14th, 2019. And it comes at $1,600.
So it was not in compliance on September 28, 2019. The code enforcement officer went back out there on October 14th, 2019,
Corresponds. He said he was gonna come back out there and check the property out.
but you don't know if
We
that
have no
happened.
documentation after that saying that he went out there or not.
There's no record or anything about compliance. Has anybody gone out there recently to see if it's in
We have
compliance?
pictures on.
Well, show me what you found today.
Okay, as of November the 30th, when we started this case, 2020, page 1, picture 1.
These are your numbered photographs.
Yes. Property has a few little grass and weeds and damages, but for most part, from what we looked at, it's still not in compliance.
Okay.
Photo number 2. It's upside down. Another description of that picture will just show you that actually it's the property 321. I think it's upside down, or we missing the top of it.
Yeah.
To give you-
Well, the original, just so for my own clarification, the original violation description looks like it was of code section 30-169, 30-170. Goes on, many violations.
Many violations.
30-171, 30-180, 30-213, and 30-32A. Some of the other responsibility is the mortgagee. Windows. So basically, in summary, it had to do with weeds and debris, windows, and prohibited conditions. So go back to number 1 and just highlight for me what the situation is with windows, weeds and debris, and prohibited conditions. What prohibited conditions are we looking at there, if you can show me?
Well, in that picture right there, in my eyesight, the windows seem to be in place. that we have some grass and weeds, a little small stuff or something, nothing that I would deem to be totally out of compliance. We do have some, as you go to a couple more pictures, you'll see where I felt like the compliance was not met. I think picture number 3
Okay.
on it is messed up and it's a cosmetic issue. Grass is starting to grow right there. Picture number 4 should show you more of the weeds that's overgrown in little areas on the side and then in the parking area right there.
Okay.
Picture 45, it shows you structure damage. The right rear side of the building has the car or something hit it and has some structural damage. And I think picture number 6 is just another view from that same structural damage. Weeds are still overgrown out there, but 7 and 8 are more or less just overview of the property of the on it and the other things that's not been grown around. But since then, the new property owner has made some drastic changes. But this is where we took, this is the pictures that we took before the transition of the 2 property owners. And this is the pictures that we took up under the Alex Fry representative.
Okay, so go back to picture number 8. And that was just taken last November.
Mhm.
And this was under which property owner?
Alex, I'm dealing with the Alex Fry, the B&B Palatka LDT.
They're the ones that have it now.
Yes.
You go back to 9, same thing. Ten, 11. And 12. And then 13. Mostly that's weeds and
Weeds and
grass growth.
on it, mostly, and then there's the structure damage.
Right. The this photo, which shows the yellow document hanging, what document is that?
That is the document that's the photo that we took when we posted it.
All right, do you know when that was
The
posted? This
notice
is
that would have been on February the 5th, 2021.
20?
21.
21, okay. Okay. Did you take the photographs you have presented
Yes.
to us today? You took all of them?
I took all of it.
And the photographs actually represent the condition of the property on the date
Yes.
you took them?
That is correct.
So I understand the allegation. And it helps if I get to flesh out, there were numbers of allegations in this. 30-169. Deteriorated structural and decorative elements visible from public right of way should be repaired, replaced. Every part or structure visible from a public right of way or abutting a street should be made structurally sound. Rotten or weakened portions should be removed, repaired, or replaced. Existing miscellaneous non-functional elements, such as limited electrical conduits, unused sign brackets should be removed, repaired or rebuilt. Mildew should be cleaned. Not more than 10% of the building shall having street visibility may have mildew. Mildew wasn't an issue with this case.
No, I didn't. I didn't see it in.
Rear and side walls of structures to be repaired and painted to present a neat and fresh appearance. Windows 3171. Every broken, cracked, or missing window should be repaired, replaced with glass. Which with the actual window issue,
The
must
window-
fit tightly, have sashes of proper size and design. Openings and upper floors of that portion of the building having street visibility should not be filled or boarded up. Or any of those issues?
No, those not visible.
You know why they cited that one? Okay. Time period of compliance, responsibility of mortgagee. Is there a mortgagee? Do you know? Okay. Well, those stay closed. So these little captions right next to these ordinance violations, does that mean something? When some say closed, some say open?
Well, those are the property that had several liens and cases on it, and some of them was closed and some of them was open.
Okay, so
We're dealing
these
with
are
the-
more than this case?
We're dealing with the February, May the 16th, 2019. That is the open one.
Right, so a lot of these ordinances cited aren't applicable to this case.
Public conditioning and public nuisances case, the grass or debris.
That's the one that's open.
Yes, that's the one.
Okay. So the ones I'm reading that say closed are not relevant to this. Okay, so the only one we're looking at is 30-32A. Prohibited conditions and public nuisances. Accumulation of trash, junk, debris, living and non-living plant material, stagnant water, excessive unintended growth of grass, weeds, brush, branches, and overgrowth. Other objectionable, unsightly, unsanitary matter, materials. Property inhabited by rodents, vermin, or reptiles. Breeding place for mosquitoes. Failure to replace or repair with similar improved material of a reasonable period. Broken and missing building components. Doors, windows, roofing material, siding, and so forth. There were some photos regarding that issue. Failure to replace or remove broken fencing, screening, or decorative elements. Was that an issue at all? Okay. So mostly it's trash and debris and maintaining the exterior of the building.
Yes, that is correct.
Okay. That explains it. Looking at all these ordinance violations, I'm not sure what for. So that being the case, what is it the city's wanting today? In the daily fines as of October 14th, 2019, reflect the last date of the previous code enforcement of an intended scheduled reinspection.
We have a correspondent from the.
So after October 14th, you don't want any fines.
Yes, correct.
So there are any fines left?
We have a correspondent letter going from the Alex Fry, I guess the representative for the property, to Ms. Jackson, stating that the property was brought up in compliance with different invoices and everything, saying that he pays to get service done. And from that point on, we can't find anything stating that it was or was not re-inspected.
So you want the difference between November 28th of 2019 and October 14th of 2019. You say that's $1,600.
Yeah, about that. The amount, don't quote me, the amount is right, $1,600.
Okay. And that assessment of getting on 10/14/19, but it's still accruing fines at $100 a day today.
Yes. As of today, the fines would be right at $49,600.
How much?
$49,600.
Okay. So you're asking the commission
I mean,
to reduce the fines and basically eliminate the fines between October 14th, 2019 and September 28th of 2019. It's not very long. Am I reading that right?
the fines compliance on October, September the 28th, 2019, that's when the fines started. As
The
of
compliance
October
date
4th.
was September 28th, 2019, in which the next day, the first $100 fine could begin.
Yeah, so that started on the.
That's on the
29th.
19th, September 29th. Then you want to end the fines on, as of October 14th, which is basically
One number off supposed to be 15.
16 days.
16 days.
So you just want to reduce $1,600 off the fine.
I'm taking the $1,600. That's. that
Okay,
was
so your
$100.
recommendation is reduce the fine by $1,600.
Now, recommendation is to assess the fine of $1,600
Okay,
because.
so
of
the fines are not accruing as we speak?
They are, but the community, that's what I'm saying, the communication between the property owner or property representative and the code enforcement officer has documentation saying that she was gonna go back and re-inspect the property. And he sent me receipts and everything saying that he had brought the property up to compliance.
So you want to reduce the total number of fines to $1,600 effective today? Just give me something.
Effective today. The fines, in fact, the fines that he would need to pay is $1,600 effective today.
Okay, and then do the other fines continue to accrue starting tomorrow?
That is, As of today, the property has been brought into compliance.
I'm sorry? It's in compliance?
Compliance.
So basically you're saying reduce the fine to $1,600. We're good. All right. All right. Based on what I've been presented concerning the situation, we'll recommend to the city commission reducing the fine to $1,600. Okay. See what they want to do with it. I'm just trying to sort out all the dates and make sure I understand exactly what we're asking for. All right. Any further questions on that one? Next case.
We have case number 201200069. Property address 319 South 16th Street, Palatka, Florida.
Okay.
The municipal code that is falls on 30-32, prohibited conditions and public
And
nursing.
for the record, is there anyone in the audience who's a respondent or representing a respondent regarding the property located at 319 South 16th Street, apparently owned by Miles Roth? And seeing and hearing no one, please continue.
Okay. First observed of the property was August the 6th, 2012. Notice of hearing from this hearing right here was done on February the 5th, 2021. Date of correction, September the 28th, 2019. Green card sign, no, that we can recollect. Complex posting, same date, February the 5th, 2021. Site posting, same date, February the 5th, 2021. First hearing on the property was or was not, the property owner was or was not present. I can't confirm. Code Enforcement Board initiated a required response to take certain corrective actions on September the 28th, 2019 of a $100 day fine will be beginning. As comments, the fines and fact conclusion was entered in on September the 26th, 2012, and the previous owner Leanna B. and Juanita Brinson, the property owner was not in compliance by October 24th, 2012. Property owner was inspected on 11/22/2013 and after being purchased by a second homeowner, which is Mac Peak, and found brought to be brought into compliance. The total fines and fees include administrative fees equal up to $9,875. Staff recommendation, Mr. Roth was aware of the lien and failed to do his due diligence. The lien should still be paid in full. But we do have a letter from Mr. Roth that he sent in to Mr. Holmes stating that he personally brought the property up to compliance and his recommendation was to reduce the fines to $500.
Can I take a look at the letter?
Yes. Should be in the paper. Should be the second page. Up under
He
the-
bought the property with a recorded lien on record.
Yes, he's actually, do you see this?
It just- Thank you, David. Lafayette, Colorado. In his letter, he says he did know the lien existed. However, did not have a chance to view the details of the amount of the lien before the sale. Decided to take a chance and buy the property anyway. So the property's in compliance now?
The property pictures here. As the pictures taken on January the 20th, 2021, the property looks pretty good. It looks in compliance, but you can see the
Right.
pictures here. No major structure, no grass, no weeds, no structural damage. The yard seemed to be in decent condition. It was January,
Okay.
so it's not a.
And I'll make note, the letter was dated January 12th, 2021. That's we got notice of this hearing. And he asked for the reduction. Do you have any objection to that reduction to $500?
Yes,
Yes, okay. What is your
my
recommendation?
recommendation that he was well aware of the fines and fees that he had when he bought the property. So $9,875 is my recommendation he should pay. That's my recommendation to the magistrate.
He admits in a letter that the lien filed by the city was recorded May 6, 2013. And is recorded at OR Book 1346, page 1770 of the official records of Putnam County. So it was on record at the time he purchased the property. He was on notice. I mean, it's, if he buys a property with a lien, he's subject, to the lien. It doesn't go away. I mean, I have no reason, not to recommend that the full amount be paid. That's up to the city commission at that point, what they want to do. There may be other, did he offer any other mitigating circumstances as to why this should be reduced?
This is not, I spoke to him just 3 days ago, Friday of last week, and let him know that his letter will speak for him. Unless you have anything else to add, and no corresponding back to that.
May I speak?
Sure.
I think we addressed this before. And I explained at that time that it has been the practice of the city of Palatka, and a policy was in fact adopted, that when a request for lien reduction was made, a series of criteria were reviewed to determine whether or not the request should be granted. I'm concerned very much about consistency, and for obvious reasons. Those of us who've lived in the law understand that if you don't have some guidelines for achieving consistency, then the next thing you have is a claim that you're being arbitrary and capricious when you handle one case differently from another. So traditionally, what we have done when requests for lien reduction have come in is we've looked at the case. We've looked at some basic factors. One is the person who's making the request for lien reduction, the person that allowed the condition to accrue in the beginning. Are they the ones that were at fault? If not, 2, did they know of the lien when they bought the property? 3, if they did or they didn't, how long after they bought the property was it before they corrected the condition that was offensive? And then 4, is there an economic hardship? And we've tried to apply those consistently because, as you well know, we get lien reduction requests by the drove. And traditionally and historically, the boards tend to grant a fair number of them because the philosophy that the city commission has advised us to follow is that we're not here to basically create hardships. We're here to achieve compliance. And if the city basically obtained the reputation that you're not ever going to get a lien reduction if you buy property and there's a lien on it, then you probably aren't going to get many people buying the property, and you probably aren't going to get many people fixing situations. So what you end up with then is the city trying to foreclose properties and get into the property ownership and sale business. So as I think, I announced this before when we talked about this. I'm going to tell you right now that if this goes to the city commission, I'm going to advise them of the policy that we have honored for years. I can't tell you how many years. I represented the city as its attorney for 20 years, and as long as I can remember, we have followed that policy. As a matter of fact, and records may not be easy to come by around this place, but the Code Enforcement Board adopted that policy, and the city commission may have too. So I'm catching
just for the
you.
record, which policy in specific are we talking about?
The policies that I articulated about how to consider a lien reduction.
Just the criteria for.
Right, the criteria for consideration of lien reduction. So I know I'm catching you blind, or to some extent, not blind, but catching you off guard. But I don't want to, on the other hand, I don't want to put you in a position of I guess, not knowing that this is the approach that we're going to take as we move forward.
needless to say, this is the first time I've seen code enforcement where the special magistrate gets involved in this decision-making process. It's usually something that goes straight to the commission, which is fine.
Yep.
We're not shying away from that. In this particular case, the question I have, if he knew of the lien and that lien had been, the closing agent, whomever it may have been, had required that lien be satisfied at the time of closing, this fine would have been paid.
Maybe.
Well, or the closing might not have occurred. I mean,
Exactly.
that's the other alternative.
The quandary that we have in Putnam County is that our property isn't worth what property in St. Johns County is worth, or property in Alachua or Volusia or Flagler.
Your day will come.
Man, it may. And then the code enforcement process is going to be a totally different process. But right now, there are people who just walk away from the property. And, you
It
know,
happens at the county a lot.
don't pay the taxes, you know, just don't pay taxes. Let it go for tax sale. So,
So is it your feeling that this is in compliance, that the commission might consider favorably?
but my feeling is that we don't have enough information and that we don't know how long it was after he bought the property that he brought the property into compliance. We do know that he bought it knowing there was a lien, and we do know that he wasn't the one that allowed the condition to exist. So I think unless his letter tells you how quickly after he bought the property it was that he brought it into compliance, then I think that's the
He
next
said he
question.
bought the property on May 14th, 2014. He does not put a date on any compliance.
Right,
And we don't have any contrary evidence as to when it might have been brought into compliance.
we don't. So traditionally what has happened is people have come before the board and said, I bought the property. I spent X thousand dollars bringing it into compliance. I had it in compliance by June 1st. I'm asking you to give me a break on this. And traditionally they do. Now, how much, you know, that there has not been a set number, but they've brought it depending upon how much work was done, how much money was spent in achieving compliance and so forth and so on. You know, I've seen them reduce it down to $500. I've seen them reduce it by 2/3. That is a area where judgment can be exercised, but in general, they have traditionally reduced a fine.
So what are they looking for the special magistrate to do in this circumstance? Put some kind of parameter on the amount?
Well, you know, this is our first special master
I
hearing.
got that.
And so perhaps this shouldn't, for our edification and as we move forward, perhaps we shouldn't bring these to the special master, you know?
Well, here's the thing. The guy's willing to pay something.
Exactly.
He's indicated so in the letter that he's presented to pay something. He bought the property in 2014. We're talking almost 7 years ago. And nobody's complained, I guess, in the last 7 years. You haven't got any new complaints about all that.
No new complaints. No new complaints.
And this property is located again on 16th Street. I have the right one? Yeah. Look at the photos.
319 South 16th Street.
It's South 16th Street. It's south of St. John's Avenue.
South of
Okay.
Reed
I know where
Street.
I know where it is.
Nope, St. John's Avenue, you're right. St. John's Avenue is the north-south demarcation.
And none of the neighbors have complained all that time.
We have no new cases shown in iWorks or ADG.
I mean, I don't want to sound arbitrary about it. The guy's willing to pay $500. I mean, you guys are out something. I mean, you can make a recommendation to do $1,500 and,
We got it broke down.
but I have to tell you, I'm not sure how to base that in any particular number in terms of what you're trying to do. I mean,
Is my turn? Oh.
yeah,
Like I said, my recommendation is open to the commissioner and the city manager's thought process.
so the mayor's going to look at you. He's an attorney too, right? The mayor's going to look at you and ask, okay, how do you come up with this number?
The numbers, it's the fines, it's the administrative fees and lien fines that was in place when he bought the property. And he bought the property aware of these fines and fees that he had.
And he's been a good citizen as far as you know since then.
I guess, yes.
I mean, I don't really have a dog in the fight in the sense of attaching a number to that. He's willing to pay you $500. If you want to ask for something more and you can base it on some reasonable
From
basis on your cost or,
from listening to the city manager and the facts that he brought into the picture, I'm willing to accept the $500
Okay.
reduction.
so let's do this. We'll enter an order. We'll enter a recommendation to the city commission based on the letter, recommendation of staff and the criteria Mr. Holmes has outlined that will recommend a reduction of $500, especially since, although he admitted that the lien was on the property, when he's taken the property and has maintained the property, at least today it's maintained, and there have been no record of additional complaints since his acquisition of the property on May 14th of 2014. How about that?
Sound good?
And here's the letter for the record, just to make sure we have that. Okay, we're making progress. Feel like you've been through the ringer yet?
I'm good. Mr.
Yeah,
Brown.
you're gonna be
Thank you.
fine.
Thank you.
It gets easier after this.
The next 4 cases you'll be hearing will be actually new cases.
Okay,
And
which one you want first?
Mr. David Green will be actually presenting.
Okay. You got 3 or 4 more?
I have 3.
3, okay.
The first case I want to do, Mr. Brown, is (221) South Fifth Street. I think Mr.
Okay,
Excuse me, sir.
and this is case number 2020-008, owner Marjorie Pinnell.
Yes.
Is that correct?
Yes.
At 221 South Fifth Street. Is there anyone here representing, is Ms. Pinnell here? Anyone representing her? No. You may proceed.
Okay. Original violations were paint deteriorating, chipping, multiple windows broken or damaged, overgrown grass. Excuse me. First observed 11/30/2020. The hearing was sent. The notice of the hearing was sent 2/5/2021. The green card was not signed. The complex posting 2/05/2021. Site posting 20/05/2021.
What alternative notice did you give them after the green card wasn't signed?
There was a door placard, a door knocker, and we sent one out through a letter through the mail.
Okay, you posted the property,
Yes, sir.
on the property?
Yes, sir.
And posted, where else do you post it? Here in City Hall?
No, we keep it on over the.
Okay. I'm sorry?
We keep it on file in our code enforcement office.
Okay, very good. So you posted at the property and at the code enforcement office. And there is an affidavit you're supposed to sign, just so you know. Okay. Did you hear from Ms. Pinnell or anyone related to her after posting the notice until today?
We had some friends stop by and discuss us about how they can help her clean up her yard while we were taking pictures. It was a church that she goes to. I spoke with the pastor when I went back and took more pictures right before we had this hearing, and he said they could help her around in the yard, but they could not go inside, could not help her with the windows.
Does she live in this house?
They didn't know, but from my understanding, she talked to the pastor, and the pastor said that she was getting out of the nursing home and was coming there, but when he came to check, she wasn't there. We noticed the lock still was on the front door, and they don't know really where she's at.
Okay. Right, proceed. You've got some violations of section 30-170 of the code, 30-171 and 30-32A.
If you,
First one, rear and side walls paint deteriorating.
yes, sir. If you go to picture number 3, you'll see the condition of the windows.
Okay. All right. The code says the rear and side walls shall be repaired and painted to present a neat and fresh appearance. Rear walls should be painted to cover evenly all miscellaneous patched and filled areas or be stucco to present an even uniform surface. So what's wrong with this structure?
The paint is chipping. Need to be painted. You see where the paint peeling off right there in the middle of those two windows and under those windows. They also had numerous complaints where the sheriff officer had to go there and clear out the house because they had squatters.
Okay. So what solution is the city looking for
We want to
on the subject of painting? I mean, does it need to be scraped, repainted, what?
Yes, sir.
Okay. The next violation was multiple windows broken or damaged in violation of 30-171. Basically says every broken, cracked, missing window should be repaired or replaced with glass. Can you show me the violations with those?
Yeah.
Okay, this is in photograph number 3. Okay. And so that window is broken,
Yes, sir.
not repaired, needs to be repaired. Anything
Yes, sir.
else?
And number 7 also, sir.
Photograph number 5, anything there? Is rotted windows? What about, yeah, there are 2 photograph 5s. I presume the second 5 should be we'll call it 5A, since there's already a 6. Now, the house I'm looking at with the boards in the windows, is that a violation?
Yes.
Okay, so that window needs to be replaced.
Yes.
Okay. Any other window violations that you can show me?
Yeah, so picture number 2 in front of the house.
Number 2?
Yes.
Okay. Okay, in the upper right-hand window?
Yes.
Okay.
It also has an abandoned car in the yard also. That would be picture number.
So we've got 2.
Number 8. Picture number
8.
8 has an abandoned car.
Okay, so the car in the yard,
Yes, sir.
is that a violation? Of what?
It doesn't work. It's inoperable.
We didn't cite it. We got 3 things that were cited. We got rear and side walls, paint deteriorating on 30-170. We have 30-171 windows, multiple windows broken or damaged, and we have 30-32A, overgrown grass and debris.
Yes, sir.
You didn't cite the car.
No, sir.
Okay, okay, you got other things. Tell me about the overgrown grass and debris in violation of 30-32A.
And picture number 5.
That's
Sure.
5, okay. Okay, what are you looking at number 5? There's a plant under the window.
No, it's not that one.
What? 6? Okay. All right. What
No,
here
it's-
needs to be
Scroll
addressed?
back up one, just one.
5A, now we're at 5A, okay. What in that photo is a violation of 30-32A.
All the grass between the house and right in front of I don't know what that is. There's a second building behind that.
Now, this house in question is the one behind this fence with the beware of dog sign on it, right?
Yes,
Okay, so you're looking at what's behind that fence?
yes, sir. All that is one property.
I'm looking at a propane tank, some blocks. That kind of thing we're looking at?
Yes, sir.
Okay, anything else? Okay. And you've had, like I said, no contact with the owner. You had contact with the owner's pastor. Nobody seems to know exactly where she is.
No, sir.
No green card sign. You posted the property.
Yes, sir.
No conversation with any neighbors or anyone else regarding this. Was a neighbor complaint? I know you take anonymous complaints here, but I'm not asking you to even name the person. I'm just.
Okay, yes, we don't put their address on there, so.
Yeah.
I don't know,
But-
a neighbor, or somebody passing by, but it's a daycare across the street, so somebody dropping a child off may have said something.
Okay. The address for the notice is 221 South Fifth Street, the
Yes.
official address and the public records. Okay. Okay, anything else? Right. Based on, and you took the photographs that
Yes, sir.
included, did the photographs actually represent the condition of the property on the date you took them?
Yes, sir.
All right, very well. So we're going to find a violation of section 30-170 of the municipal code of City of Palatka regarding rear and side walls, specifically that the paint is peeling and deteriorating and does not present an even appearance as required by the code. We'll find a violation of section 30-171 regarding windows. Multiple windows as shown in the various photographs were either broken or damaged or broken and plywood covered, but have not been repaired. And finally, section 30-32A of the municipal code prohibited condition due to overgrown grass, debris on the property as identified in the testimony and photographs. We're going to issue an order requiring compliance within 30 days of the date of the hearing. Today's date is February 16th,
16.
and the 18th, March 18th of 2021. The owner is to bring the property into compliance by addressing the deteriorating paint, which may require scraping and repainting, but nonetheless to give an even appearance on the property, to repair the windows that are broken or damaged or improperly covered, and to remove debris and mow overgrown grass on the property. In the event of non-compliance, a daily fine of $75 a day will commence on March 19th, 2021. What's the $319 in fees? That's an unusual number. Okay. You can put in a fine. Administrative fines, cost repair and maintenance. In addition to fines, the code enforcement board or special magistrate may impose additional fines to cover all costs incurred by the local government enforcing its codes and cost repairs pursuant to section 1. Any ordinance imposing fines shall include criteria considered by the code enforcement special magistrate determining the amount. So is there an ordinance about what we can charge? You can charge administrative fee. I know the county charges $100, for the cost. So is there a provision in ordinance on how to assess these costs? I'm sorry? Who gave you that?
For right now,
Well-
let's say no, and we'll correct that.
Yeah, okay. You see what I'm getting at, in terms of what the fees are. It's just what the statute allows you to do. And that's all we're allowed to impose on this situation right now. And does the enabling ordinance talk about assessing fees? I know you haven't been doing it, and you can. You just have to go through the right process to get it done. We don't have it right now. Okay, we're not going to assess the fee, but we will assess the $75 a day fine commencing on March 18th, 2021, even in non-compliance. Okay? All right, next case.
This case is 510 South 19th Street.
510, okay, have it.
Abandoned vehicles and property, overgrown grass, broken windows, debris, vehicle blocking the sidewalk. When I went to inspect it, my first time to inspect the car, the vehicle was gone, and it's still gone.
Okay,
So what will be left is overgrown grass, broken windows, and abandoned appliances.
all right, just for the beginning, Stacy Clements is the owner of record of the property.
Yes, sir.
It looks like someone has signed the green card.
She signed it.
This is a very peculiar nomenclature that the post office uses because of the COVID. They start putting down these numbers. So somebody got the card
Yes,
at this address. Did you otherwise post the property?
yes, sir.
Okay. You posted it at the code
Yes,
enforcement board, okay? You've got 3 ordinances cited:
Yes, sir.
paint deterioration, multiple windows broken, and overgrown grass and debris. Show us what you've got in terms of
Picture
violation.
number 1. That's the one with the car gone. That's how it looks now.
Okay.
If you go to picture number 6, you'll see the broken, I guess, glass door.
Okay.
And picture number 8, that is where the appliance and the debris is in the yard.
All right. This is the violation 30-32A.
Yes, sir.
Okay. What else? Anything else? Well, let's do kind of methodically. What other violations of 30-32A are you looking at? Anything?
What I'm thinking is that she got the green card and maybe she cleaned up around the grass, overgrown grass, but it still has the broken windows and the appliance and the debris outside in
Okay.
plain sight.
So in terms of,
She moved the car.
so mostly it's this debris you're showing me in photograph 8,
Yes, and
but the overgrown grass has been addressed. And you haven't heard from her as to why she hasn't removed this material?
No, sir.
Have you heard from her at all?
No, sir.
Okay. Okay, what about multiple windows broken and damaged in violation of code section 30-171?
That was the one that I seen. Well, this is a porch with the glass door that's broken. Then you come out to
This
the
is the front
porch.
door?
Yes, sir, the front door. You come out into the porch.
You're
So
looking at the photograph 6?
yes, sir.
Okay.
You can see it clearly right here. That's, I guess, the screening is gone. But on the front porch, going into the front door, all the screening is gone.
Those windows are broken also on both sides? So we're just looking at the front door or more windows than that?
The 2 windows on either side, they're not
Okay,
broken.
are they also broken?
They're not broken.
Okay, what else?
Like I said, when you walk on the front porch, all the screen is going out the front porch, and you see a dryer and other debris is covered up. I don't know what's under that, or under those tarps.
So the windows that need to be repaired, the front door and the 2 windows on each side of the
Yes,
door, and anything else?
The debris,
3?
the debris.
Oh, okay, I'm talking about windows.
Windows. No, sir. That's
Okay,
it.
so we've got the front door, those 2 windows, and the debris in number 8.
Yes,
Okay, what about paint deteriorating?
yes, sir. Get another picture in the front of the house. On number 5. It's peeling off.
Which, we look at number 5.
Yes, sir.
Okay. So what's wrong with the paint?
It's peeling off. That picture was taken in a glare. But if you are there in person, you can see the painting deteriorating and needs to be painted.
How is it? I don't mean to beg the question. How is it deteriorated? Is it peeling?
It's peeling off, yes, sir.
Okay. Is there any mold or mildew on
No,
it?
sir.
Is it faded or
Yes, sir.
inconsistent?
Faded.
Inconsistency is one of your code violations. Okay. So basically it needs to be repainted
Yes, sir.
to a consistent.
Yes, sir. Consistent color.
Have you talked to any neighbors concerning this property? Have the neighbors talked to any of the owners? Do you know?
No, sir. I think a neighbor the one called it in.
Okay.
But when we went by, there was no one there.
And Mr. Shepherd,
Yes.
he says there is an untagged, non-running vehicle partially blocking a city sidewalk, lawnmowers, washing machines, assorted junk and litter. That's all gone?
Yes.
Or is it under the tarp? Do you know?
The tarp is still there, sorry. It's a picture of the tarp on the, picture number 2. Yes, that's the one picture we went to and I said I didn't know what was under the tarp. That was picture number 8.
Number 8?
Yes, sir. I don't know what's under there.
Okay.
We can see half of the lawnmower, I guess, but
So has all the debris now been just clustered into one area?
yes,
So she has been moving something, or someone's been moving
Yes.
something. But they did clean up the yard.
yes. I guess they moved it all
Was
back
this,
to
was
the
this,
side.
was this debris all over the yard previously?
This case predates me, so, and I don't think they took any pictures before.
Okay. Anything else?
No, sir.
And you took the photographs you presented today as demonstrative evidence?
Yes, sir.
And they actually represents the condition of the property on the date you took it?
Yes, sir.
All right. Based on the evidence and testimony presented, we're going to find a violation of section 30-170 Municipal Code of City of Palatka regarding the paint deterioration, the uneven paint coloration, and the peeling paint on the visible on the structure. A violation of section 30-171, multiple windows broken or damaged, and basically the front door and the 2 windows on each side of the front door. And a violation of section 30-32A of the city code, prohibited conditions and public nuisances. The overgrown grass has been addressed, but there is debris in the yard that's basically located as in shown in photograph 8.
Yes, sir.
Okay. We will find a violation and require compliance within 30 days of the hearing, which will be on March 19th. Let's say 16th. March 18th, 2021. In the event of non-compliance, a fine of $75 a day shall commence on March 19th, 2021. Okay. Final case.
2121 Oak Street.
This is 2121 Oak Street,
Yes, sir.
case number
2020-014 is the case number.
This is the life estate of Ruthie Camille Watson. I see no one in the audience who might be a respondent. I don't think Mr. Holmes is going to be responding with regard to that. Just so I can inquire, did we get a green card back on the
Yes,
notice?
sir.
It's signed by whom?
I don't have it, sir.
But you did get the green card back.
Yes, sir.
It needs to be in the record.
Yes, sir.
You have any contact
No, sir.
with Ms. Watson or anyone related to Ms. Watson or anyone representing her?
No, sir.
There's no. Maybe the neighbors indicated they've seen her or talked with her about any of this?
No, sir.
Okay. And you know who made the complaint without telling me their name? Was it a neighbor or somebody driving by? They talked to you is what I'm getting at.
Oh, okay.
You've heard about this case.
Mr. Cartwright.
Who?
Cartwright.
When he starts staring at you, it has to be good. Okay. All right, you've got 4 violations, 30-170 rear and side walls, paint deterioration, 3171 windows, multiple windows broken or damaged, 213 responsibilities of mortgagee and owners. Is there a mortgage on the property?
No, sir.
So this
Before
is
I
about
came
the,
here,
this is about the owners.
No, sir.
Okay, I was just trying to see why we got it in there. And then you've got 30-32A, overgrown grass and debris. So go ahead and show me your proofs on the
Yes, sir.
violations.
Picture number 2.
Okay.
Picture number 3.
And this is going to the
This is in front of the house.
weeds and debris,
Yes, sir.
mostly weeds in these 2 pictures?
Yes.
Okay,
Um,
it looks pretty high.
yes. Picture number 5.
Okay,
You can see the debris. I want to put we think someone's living in there, squatters or whatever.
and there's no glass in the front door?
No, sir. There's no,
Any glass in any of those windows?
no, sir.
Okay. The fence is in disrepair.
Yes, sir.
Is this house unsecured? I mean,
Yes, it is. Picture number 7, some more pictures.
just out of curiosity, is that also a violation of your code?
Yes, sir.
You didn't bring it up. I'm just
One
asking.
Yes, sir.
Okay. Number 7, more weeds.
That's on the side of the house.
Okay,
You see all the windows are broken out right there.
okay. Okay, so that's overgrown grass and mostly overgrown grass. Can you see any debris in any of these photos? That's an issue?
No, sir.
Okay, let's go back and let's look at, again, the broken windows. You had one photo which showed that the front door and all the windows to each side of the front door are
Yes, sir.
non-existent.
Yes, sir.
Looking at number 5, any other photos regarding windows?
Front of the house, the main, all the windows are broken out. The side is okay.
Okay.
And
What
I
about
couldn't go in the neighbor's yard because that I didn't know them. I don't know. They didn't give permission, so I couldn't take a picture of the other side of the house. The left side of the house if I'm facing it.
Okay. Okay, what about paint deterioration?
As you can see, the paint's peeling off. Someone doesn't even have
It's a-
any paint.
Is
On
the
it.
paint peeling?
Yes, sir.
What about evenness of
Yes, sir.
coloration?
That too. And it be painted over to a consistent.
Any other photos regarding the paint? Is this house savable realistically?
I repaired. When I was in water and sewer, like I repaired a meter there. Somebody was actually living there, and so I don't know what's going on with the structure or the inside of the house, but someone was actually living there, and it looked almost like the same way it did now.
Okay. I mean, and I'm gonna find their violations, but I'm like, at the end of the day, is this house worth saving? Is anybody going to do that? This address on Oak Street, this is south of
It's at the end
St.
of.
John's.
It's at the end of Oak Street. If you turn off Mosley, if you turn off Mosley
Yeah.
to Oak Street, it's that last
That far
house.
down? Okay. Still, it's a nice neighborhood
Yes, it was.
in terms of what's going on there. Okay. Anything else? Okay. Based on the evidence and testimony, we're going to find a violation of section 30-170 of the municipal code, rear and side wall with paint deteriorating. Mostly the photo is of the front of the house, but
Yes.
the rest of the house is
I
consistently
have
got
side- I have-
deteriorating
I
paint.
have the side of the house from the, not road, from the road on the side of the house. That's what I showed you earlier with the windows was intact, but the, excuse me.
All right.
Paint is peeling.
A violation of section 30-171 windows, multiple windows broken or damaged. Doesn't seem to be any windows in the house based on the photographs. Section 30-32 due to the overgrown grass on the property, which is pretty high. I didn't really see too much debris other than the overgrown grass. I don't know what to do with responsibilities of mortgagee and owners of vacant, blighted, unsecured, or abandoned structures other than they need to, I mean, the owner's there, there's no mortgagee you know about. That's fine. We'll just find a violation of the three sections of the code, unless you got something you want to add to that. We'll issue an order requiring compliance within 30 days of the date of the hearing, which will be on March 18th, 2021, excuse me. A fine of $100 a day will be assessed in the event of noncompliance, first day of noncompliance being March 19th, 2021. We'll go from there. All right, anything else?
No, sir.
All right, we're going to adjourn the meeting and let me know when you are off.